Second speaker here is Garrett Roe, also an IRLI staff attorney. He's going to give a summary of the RICO harboring case and teach a tech worker suit against DHS.
I'm going to talk about two cases. One, of course, the RICO case I'll start with. It's called Mochi v. Connolly Properties Incorporated. We found out about this case from an employee of Connolly Properties who was a leasing agent. And Connolly had set up the landlord had set up this organization where they would screen tenants to various properties. He'd get some kind of a paper saying who the tenant is, and he'd screen low-income African Americans to one property. He'd screen Hispanics to another property. He'd screen legal aliens to another property. Screen people with certain incomes to another property, which, if you're familiar with federal law, is a violation of many violations. But this is the typical problem we see in a lot of these communities. You'll see a landlord who's renting to illegal aliens. The landlord doesn't upkeep the property. Pretty soon crime increases, the buildings start to deteriorate, day laborers start lining the streets, and the U.S. citizens in the area are in serious problems. We've seen state and local governments trying to deal with these problems, but in courts there have been issues involving First Amendment issues or involving racial profiling issues. Now, we have had success recently in the employment sector. I'm sure you heard about E-Verify earlier. Recently, in the Ninth Circuit of all courts, claimed that the Arizona ordinance was upheld, which mandated E-Verify, so that the state can require employers to use E-Verify to check legal status. Well, while that's good and it helps out a lot, it only goes so far because there's the other issue of harboring, which is what this RICO case deals with. This would be more the typical situation where there's a large meat packing industry, for instance, it's a small town, and none of the illegal aliens actually live in that town. They live in a town 10, 15 miles away. So the town that actually suffers the consequences is the town 15 miles away, and they can't do anything about the meat packing industry, for instance, that meat packing company that is causing all the problems. If we can somehow get harboring, some kind of a harboring case that would allow these citizens to have some sort of legal recourse, that would potentially take care of it. Now, RICO does allow for civil remedies for immigration violations. We've seen a lot of success in the employment-related immigration recently. This is actually the first harboring case, though, in a civil RICO. It involves the case where a landlord would be renting to illegal aliens and U.S. citizens will be harmed as a result of that. Now, the importance of this case, as I just mentioned, was the situation where the small town is dealing with illegal aliens renting, but it's also important because it'll set a precedent for the private bar. It's hard sometimes to get the private lawyers to bring cases like these that are more, they're a little more of a risky theory because they haven't been brought before. And so if we're successful in this case, that could encourage the private bar to bring more of these RICO cases dealing with these landlords. It could also deter other landlords from doing it. So at that point, we'd have both the E-Verify situation with employers, and we'd have the deterrence of the landlords. The other side realizes how important this is. Just, I think Friday, we got a notice from the ACLU, the Asian American Legal Defense, MALDEF, and the Seton Hall Law School wanting to get involved in our case against us. The second case is the Programmers Guild versus DHS. This case involves three organizations: the Programmers Guild, the American Engineering Association, and Bright Future Jobs, along with 12 U.S. citizens and 2 students. And this is in response to DHS's emergency rule involving OPT, which stands for Optional Practical Training. Now, what optional practical training is a tool for foreign students after they've completed, or while they're in school, prior to this rule, they could be employed for 12 months with an employer in the United States. What this rule did was expand that from 12 months to 29 months and allow them an additional 4 months of being on unemployment as long as they had applied for an H-1B visa. What happened? The reason this came about was because of comprehensive immigration reform last year. Once comprehensive immigration reform failed, which was going to increase the number of H-1B visas to, I think, approximately 250,000 visas from 65,000, the business leaders went to the administration and said, hey, we need these workers. And so they came up with the idea of expanding the OPT. Now, what the OPT expanded to was what DHS estimated was 32,000 additional people would be eligible for working. They thought 12,000 might take advantage. this is even worse probably than the H-1B visas, because not only is an additional 12,000 people in the workforce, these people are not responsible for FICA taxes, and there's no DOL certification, Department of Labor certification, so it's really an unfair, unfair increase in the workforce already than the H-1B was. Now, the issue here is, of course, standing, which is always a problem. But what's nice about this case is there's something called economic standing, economic competition standing. Standing is basically the ability to bring a case. Now, in this case, the tech workers are in a field that all these workers will be working in. So they're the ones who are going to be specifically competing for jobs. And because of that, they have a certain kind of injury that will allow them, hopefully, to bring this case. Now, after we get past that hurdle, we feel pretty confident because, one, it was introduced with no notice and comment, which is the only real protection that U.S. citizens have, which is the ability to tell the government, no, this isn't a good idea because of X, Y, and Z. They determined this to be an emergency situation because foreign students who are here on a foreign visa were going to have to go back to their own countries like they were required to under the visa, under their visa originally. But that'd be a bad idea, so they want them to stay in this country to get an H-1B visa. And the second is that there's no statutory authority to actually bring this because there's nothing in the F-1 visa statute, which is the student visa statute, that allows them to be a de facto H-1B worker. So again, the importance of this case is that if we can somehow shut off this administrative course, like we're seeing from DHS, and you saw the OPT, you also saw the increase in H-2A workers, letting them stay for an additional 3 years. If we can somehow shut that avenue off, it'll force the other side to bring it back to Congress, where Congress actually has to have an open debate on the subject. Again, this is also the first that I know of to actually challenge one of the DHS authorities like this from our side.